Just give me one more second to. All right. Well, good morning, everyone. My name is Laura Reichart. I am the director of the Hawaii State Center for Nursing, and we have a full Zoom room today. So thank you all for taking time out of your schedules. This meeting is for the nurse license compact study, and we have guests from NCSBN today. So we will have most of our time spent listening to them, but first and foremost, we're going to start with welcome and introductions, and then review our minutes that were sent out last week. So with that, I am going to open up our roll call document, and I'm going to go through that, and then we will start our meeting. Okay, let's see. I have to make this very small to catch all of our people in our working group. So I'm going to go down the list, and if you can just say present, that would be very helpful. So first on our list is Alani Kyogi. Right, present. And then we have Rena Chung with Rico.
Present.
Thank you. And then we have Leanne Tashima and Chelsea Fukunaga.
Here.
Present.
Thank you. Next, we have our elected official, Senator Keoho Kulole, or delegate. Senator San Buenaventura, or delegate. Oh, I see Amelia.
Here, Senator should be joining us soon. She's just getting off her flight right now.
Oh, okay, thank you. And we are recording this if she is stuck in traffic. And then next we have our representatives, Representative Della Bellotti or delegate. Thomas coming right now. We will mark him. And then we have Rep Nakashima.
Present.
I think you are our first on our call. Thank you for being here this morning. And do we have Lori with us as well? Or is it just
Yeah, she's listening in.
Hi, Lori. Next page, Heckathorn Choi. I think I saw Paige. Oh, there she is. And then we have Jesse Sliva from HGEA.
Present.
Jennifer Giesman, I saw you pop in. And we have both Linda Beechnor and Nancy is right behind. Hi, Linda. All right, and then Amy Ono and myself, Laura Reichart. All right, so thank you, everyone. And then we also have guests joining us, but for the sake of time, we're just going to wave hello and thank you for joining us. Next on the agenda is we are going to review and approve the minutes, which were sent out earlier. As we stated in our first meeting, we're going to be writing our minutes in report form. So as these meetings progress, we will be moving towards having a written report. So does anybody have any comments or corrections to the minutes as provided?
You need a motion to approve those?
Yeah, let's take a motion.
This is Beechnor. I'll move to accept the minutes as written.
Thank you. Any second?
I'll second. This is Paige.
Thank you. And then we have our two co-hosts. So I want to welcome our guests from NCSBN. They are the state advocates. We have Nicole and Robert, who will be joining us, Nicole Livanos and Robert Krebs. I had a very nice conversation with them last week, so thank you very much. And they remarked to me that they go, well, nobody has ever asked how to join and leave the compact. So I just want to say, I thought the best framework, because we have such a short amount of time, was to treat the nurse license compact and actually asking questions of them, kind of like you set up a puzzle, which the way I approach it is get the edge pieces first and kind of try to fill everything else in. So that's the approach today that I hope that we can have as our takeaway. We have supporting resources that were provided in advance, and we can share them if needed in this meeting. And so the resources do include the Nurse License Compact Model Act, the Nurse License Compact rules and the proposed rules, and then several articles related to the various topics, in particular the discipline, which has the most literature written about it. But what I would like for us to have as a takeaway is kind of how the Nurse License Compact is formed, what it is, what the purpose is, and logistically the administration, as well as any of those fiscal responsibilities that we may incur, or changes to our fiscal standing in the state, revenue changes or cost savings. And then there's a large number of questions about discipline that was in the study, and I know that Nicole and Robert will be a wealth of knowledge related to that. And then finally, workforce planning. So how the Nurse License Compact impacts, addresses, supports, helps workforce planning, or what considerations Hawaii may need to take if it adopts the Nurse License Compact. So I hope that this is a very large conversation. The whole 2 hours is actually dedicated to listening to our colleagues from NCSBN. And we do have room later on in our study. So if we do have need for additional questions, then I hope that we will be able to invite Nicole and Robert back so we can continue that conversation on a later phase. With that, I am going to pass the mic over to Nicole Lavanos and Robert Krebs so they can continue the conversation. And thank you so much for being with us today.
Thank you so much. Hopefully you all can hear me. Very excited to be here. I'm going to share my screen so that hopefully you can see my PowerPoint. Let's see. And then I'm going to put it in full screen mode if that works for you all. Can you see my screen?
Yeah, that looks great. Thank you.
Okay. All right. I'm going to stop my video just while I talk to save some bandwidth. So hello, everybody. So my name is Nicole Lavanos. I'm the Director of State Affairs for the National Council of State Boards of Nursing, and I'm here with my colleague, Robert Krebs, who is an associate within our State Affairs office. So we are, of course, here to talk about the Nurse Licensure Compact, and we really appreciate the invitation from Laura and from the Center for Nursing to discuss this important issue and hopefully help guide and provide helpful information as this working group takes on the important task of studying the feasibility and impact of the Nurse Licensure Compact. So I just want to say off the bat that if there is something that we don't address or you have questions on throughout the presentations, I know Laura has built in some open discussion sections, which we will have breaks in our slide for. Really appreciate getting any questions, any comments at that time. And yeah, so we will go ahead and get started. So I want to talk a little bit about the overview of what we're going to discuss today and the current status. And I think Laura set it up for us. Great. So we're going to talk about the current status, sort of the state of the states. Where are we today with the Nurse Licensure Compact? Want to talk about NLC operations, how the NLC works, you know, talk about the Model Act a little bit and how that operates, as well as the governing body, which is the NLC Commission. I want to talk about the fiscal impact, so the impact to Hawaii, what the impact has been in other states for joining the NLC. Talk about the discipline, how discipline works under the NLC. Talk about a really great tool, eNotify, which has a nurses component as well as an employer component. Talk about information sharing. How is information shared between party states who joined the NLC to ensure public safety? How do investigations work? So what happens if a nurse is disciplined in one state, if conduct occurs in your state and they are practicing pursuant to the compact in your state at the time of the occurrence? And then finally, as Laura mentioned, we'll talk a little bit about workforce. We'll talk about workforce planning, as well as what some other states have done and included in their NLC legislation that has helped to strengthen their workforce and reporting of multi-state licensees in their state. So starting with the current status. So where are we today with the Nurse Licensure Compact? So currently we have 41 jurisdictions who are participating in the compact. Sometimes I'll refer to these as party states or member states to the compact. So of those 41 jurisdictions, 39 of them are states, and then we have the territories of Guam and the Virgin Islands. So in 2023, you'll look at sort of what the landscape was here on this map. So in 2023, we had 2 states join the NLC. That was the state of Washington, who joined, I believe, in around April, and then Rhode Island that joined in late June, actually on their last day of their legislative session. So we went from 39 jurisdictions to 41 in the 2023 legislative session. And in addition to that, we had 8 additional introductions in states, as well as the District of Columbia. So you'll see that in this map in green are those states that introduced legislation in this session. Very excited about that. We only had 3 jurisdictions, California, Michigan, and Connecticut, that did not introduce NLC legislation this year. So we're very excited about how many states are exploring the NLC and having the important conversations as Hawaii is having here in this work group. Important to note that although many of the legislative sessions on the screen are over, not all of them are. So we continue to have active NLC legislation in Massachusetts, as well as the District of Columbia. In fact, DC's councilman just introduced the NLC about 10 days ago. So very much so still in the thick of it for some of these states. Others, the bill will carry over into the 2024 legislative sessions, and in other states, you'll be starting from scratch with a newly introduced bill. So that is sort of the state of the states today. So I'm going to jump into NLC governance and operations. And I think the way that Laura set up the agenda was question-based, so question and answer based. If there's something that, hold on, we need to go back to 101 on this certain topic that you just answered a question about, please, again, feel free to take note of that and ask us during open discussion. Be happy to dive in to further detail on any of this. So first, joining and exiting the Nurse Licensure Compact. So how does a state join the NLC? As you likely know, and we just talked about the state of the states and having pending legislation, a state must enter the NLC by enacting the NLC model language. And this legislation cannot have any material deviation. So compacts are contractual in nature, which means that in order for Hawaii to be joining the same compact as Colorado, you need to enact substantially similar language so that you are entering into the same contract to govern multi-state licensing. Once you have enacted the NLC, an enactment is by passing a law. So that is either the legislature passing it and the governor signing it, or the legislature passing it, the governor vetoing, and the legislature successfully overriding a veto. So those are the 2 only ways to enter the NLC. You can't enter the NLC through executive order, through any sort of decree, and you have to enact the provisions of the compact into law. So once you have enacted in one of those 2 ways, what does NLC implementation look like? So a state then moves into the implementation field. And that is really going to look different depending on the state, mostly in the way of your IT system any uniform licensure requirements that are in the NLC that you're not already capturing as part of your application process for nursing, you will then add that in. So there is some administrative time, administrative costs, and sometimes minor IT upgrades that are needed to be made in order for a state to come on board. Luckily, boards of nursing have access to, NCSBN's IT team to talk with them about how this all works, what might be some updates that need to be done in order for the state to be a fully participating state and implement the NLC. There are some states that have chosen during implementation to do what's called a partial implementation. So what this looks like is, let's just take Washington, for example. They have chosen to, they enacted the NLC this session, and they're in the implementation process of fully implementing it. However, they've decided that while they're in that process of fully implementing it, they will allow multi-state licensees to start coming into the state. That is while they are making changes to their system in order to start issuing multi-state licenses. So this is something that New Jersey did during the pandemic because they wanted to be able to take advantage of having multi-state licensees come and help with hotspots and with the nursing shortage that they were experiencing there during COVID and the need for providers. So some states will choose that path, others do not. They just simply wait until they're all ready to go to accept multi-state licensees and just begin issuing licenses. So once you are fully in, let's talk about how you would exit. So for all interstate compacts, you must enter and exit the same way. So in order to exit or withdraw from the nurse licensure compact, you will do that by enacting a statute that repeals the NLC statute. So again, this can be done by the legislature passing it, the governor signing it, or the legislature overriding a governor's veto. So the same two ways you can enter are the same two ways that you can exit. Again, it's not permissible to exit by executive order by the governor or an administrative action or anything like that. You have to enter and exit in the same way, and that is by enacting legislation. So let's talk about the Model Act a little bit. So what exactly are you enacting? What limitations do states have if they enact the NLC? Can you amend the Model Act? So we just discussed how compacts are contractual in nature. So you must enact the Model Act with no material deviations. So no state also may unilaterally alter the compact. So Colorado couldn't decide tomorrow that it is going to start charging $500 for any multi-state licensee that practices in their state. That would be changing the terms of the compact, which the other states did not enact into law. Therefore, Colorado would not be participating in the same compact as the other 40 jurisdictions. However, that being said, although the contractual nature of the compact and its provisions have to remain intact, states can amend the laws and the bills in the NLC legislation to impact the compact. So they may add additional language to their bill enacting the Model Act, provided that such language is not a material deviation. So some of the examples include, and Robert and I are going to talk about the first two I'm going to talk about right now after this, and then Robert will bring up the last one later on in the presentation. So there are two ways to amend your bill that contains a nurse licensure compact. One is through enabling language, the other is through conforming changes to existing state law, and lastly, getting unique to issues that might arise in your state, such as employer requirements on workforce data reporting, continuing education, etc. Again, we'll cover that last one later on. Oh, I see that there's a hand raised.
Yeah. Hey, Nicole, it's Paige from the Healthcare Association. I think one of the questions I would have, because it got brought up, I think when we were talking about some of the other compact legislation this past session, was the availability of guidance on what we can do as a state. So if we did want to make change, is that something that we could work with you guys on? Has that been done in other states where if folks want to make a change, like they want to put in data reporting requirements, that sort of thing, we can work with you guys to make sure that anything we're doing is okay? Is that something that you guys are able to do?
Yeah, thank you so much for that question. And that's a really important point. Obviously, when you're pursuing NLC legislation, there are stakeholders, that have pursued it and lawmakers that have introduced it because they want to join this compact. So we want to work with you to make any language that's added, it does not constitute a material deviation. How we do that on our end is that we have a legal review conducted by the NLC legal counsel, who reviews the bills, reviews any of the language, make sure that it's not a material deviation, and basically okays it or talks about ways to amend the legislation to make sure that their material deviation is not there. So yes, we can work with a state in crafting that language or simply reviewing that language. We're happy to work with states, and we've done so in all of the 41 jurisdictions so far. So thank you for that question.
Thank you. Thanks, Nicole.
Yep. So going back to additions to model language. So again, I'll cover enabling language and conforming changes. So enabling language is really just to provide clarification. So I'll give you an example. In the Illinois Nurse Licensure Compact legislation, there's a provision added that addresses state labor laws. The Nurse Licensure Compact does not supersede existing state labor laws. Now, this is a clarification because nowhere in the compact does it say that the compact would supersede existing state labor laws. But it's important for Illinois, they wanted to put in this provision to ensure that this bill is not going to supersede existing state labor laws. That's not changing the materially the compact, it's simply providing clarification. Another example is in Texas. So in Texas's law that they enacted for the NLC, it reads that the executive director of the Texas Board of Nursing is the Nurse Licensure Compact administrator for this state. So the compact requires you to have one administrator per state, and that's the head of the state licensing board. This is simply clarifying that in Texas, the head of the state licensing board would in fact be the executive director of the Texas Board of Nursing. So again, not changing anything material about the compact, simply adding enabling language for clarification. Then we have conforming changes, and this really depends on your state and really how legislation is structured in your state and drafted. So this would be one of those questions for those amazing legislative drafters that we all have the privilege of working with and helping us achieve our policy goals. So the goal of conforming changes is, to ensure that privilege to practice, which is what a multi-state licensee holds when they're practicing in your jurisdiction, equates to licensure for provisions where it's appropriate. So for example, in Alaska's legislation, you'll see that it references many sections across different codes, so not just in the Nurse Practice Act, but across different codes, where it mentions a nurse, a licensed nurse, they have added language to say, or holding a multi-state licensure privilege to ensure that in that provision of law, this one, which I pulled, deals with liability for administration of a blood test. The definition of healthcare provider referenced a licensed nurse, and so therefore they added or a multi-state licensure privilege to make sure that those nurses were covered and defined as healthcare providers under that act as well. So this might, again, this is legislative styling, so not every state does this. The compact does have provisions that say that you are, for all intents and purposes, treated the same as a licensed nurse in the state when it comes to following state practice laws. However, many states do construct their NLC bill to make those conforming changes. So I will now turn it over to Robert to talk about NLC Commission governance.
Thanks, Nicole. And it's great to be joining everyone today. Just in the interest of avoiding any hiccups or blips with the audio, I'm also going to hop off camera. But before that, I see we have a raised hand from Joan Kraft. I just want to make sure we get to that question before we move too far forward. So Joan. I believe you're on mute.
Thank you. Hi, I'm from the Hawaii Nurses Association. And I have a question about, and maybe it's going to be answered here. How does the Model Act, how does that get amended?
So yeah, and I can take that question, Robert. Thank you for that question. Apologies for not seeing the hand raised. So how a state may go about amending the compact. So
No.
a state, Oh, go ahead.
No, I mean the model act, not the compact, but the model act.
So how a state might go about amending the model act? So do you
Well,
mean
yeah,
like
well, yeah, just in
rewriting
general,
the
how does-
compact?
Or making change, not to the compact, but to the, so the compact says that we have to be in the model act is the rules, right?
Mhm.
So how does the
No,
model
the model,
act get amended?
so the model act is what you pass into statute. And so in order to amend the model act, you would be changing the provisions of the compact.
Does the model act ever get amended, or is it a static document, never changes?
So the model act has been changed once. So the compact was first introduced and first drafted by boards of nursing in the late 1990s. And then in 2015, boards of nursing came together to modernize the NLC. And because those changes that they wanted to make were material, they were significant changes, they had to draft a whole new compact, and each state had to then go pass it into law and enact it in order to join. So we went from having 24 states, which were in the old NLC, to the current NLC, which has 41 jurisdictions. So that is because they were substantial and material changes. Each compact state had to enact the new compact in order to become a part of it.
Okay. So in other words, it was changed once, and then the process is that if it's changed in a material way, well, I don't know who determines what's material, then each state would then have to do new legislation or re-up their legislation in some manner for any material changes.
Exactly.
Thanks.
Yep.
All right, so what I'm going to turn to next here is the NLC Commission, which is the governing body for the compact and how it works. So the NLC Commission is quasi-governmental in nature, and it's a joint public entity of the states. And this type of structure is applicable to compacts generally. It's not something that's unique to the NLC. So many other compacts have this same commission structure. And what it does in essence is to ensure that issues of common concern amongst party states to the compact can be addressed efficiently. Speaking to the NLC specifically, the membership of the NLC Commission includes the head of the regulatory board or their designee from each of the party states, and each of these representatives, that is each state, receives one vote. So among the jurisdictions that currently participate in the NLC, the majority of commission administrators are the executive director of their state board of nursing. For example, of the 7-member executive committee, the NLC executive committee, 6 of those 7 are the executive director of the state board of nursing. However, not all states choose this route. Colorado, for example, has named a representative from their Department of Regulatory Affairs to serve as their representative to the commission. And then another question that we commonly get is, how is the commission funded? So this is funded through a $6,000 annual membership fee from each party state. And the NLC Commission also has a memorandum of understanding with NCSBN to provide staff and support services to help the commission fulfill its duties and responsibilities. Next slide, please. So what are those duties and responsibilities specifically? Regarding the commission, its core function is to ensure the operational success and state compliance with the NLC. So the stated mission is to facilitate cross-border nursing practice through the implementation of multi-state licensure and to enhance public protection by enforcing compliance with the compact. Regarding the party states to the compact, their primary duties and responsibilities are to maintain their authority over nurse licensure, practice, and discipline within their state. And again, each party state has a seat on the commission, so they may attend commission meetings, vote on proposed rules, and the like. Another question that we've got is surrounding closed non-public meetings, and I just want to be able to hopefully clarify some of those things. So the commission's meeting procedure follows well-established public meetings law. That means that the commission provides public notice of all scheduled meetings and that these meetings are open to the public. In certain circumstances, however, the commission may find it necessary to meet in a closed session. So in Article 10, Section A, subsection 5 of the Model Act, there are 10 circumstances listed that necessitate a closed session. These can include things like potential non-compliance of a party state, current or threatened litigation, and more, things like potential disclosure of identifying information. And so if a meeting is closed, either totally or in part, the commission is required to take their minutes, summarize and justify any actions they take, and also fulfill other requirements. These minutes and supporting documents may be released, however, by a majority vote of the commission or by a court order. So to kind of wrap that up, the NLC Commission follows the Administrative Procedure Act for its meetings and rulemaking process. And again, this is language that you're going to find across compacts such as the IMLC, the Interstate Medical Licensure Compact. Next slide, please. So now I'd like to turn to rulemaking specifically. So I'm going to talk about both the Commission's rulemaking authority and then also the potential impact of some of the current proposed rule changes. So as I mentioned previously, the Commission's rulemaking authority follows the Administrative Procedure Act, and critically, there are limitations around the Commission's rulemaking authority. That authority is limited to the operations and governance of the compact, which means that the Commission has no ability to promulgate rules that are going to change the uniform licensure requirements, state scope of practice laws or licensing requirements, disciplinary procedures, or any other substantive aspect of nursing regulation. So that is, each party state to the compact retains their full authority to set state licensure requirements, establish the scope of practice, and outline disciplinary procedures. Now, the Commission is also in the process of considering proposed rule changes that, if adopted, will become effective next year. And if you want to look at all of this information in its totality, you can find it on nursecompact.com. So this information that's been posted includes things like the language of the proposed rule changes, the dates for when the comment period, public notice and comment began and closed, the comments that were submitted during that time, when those proposed rules were publicly heard, and when the rules will be voted on. Next slide, please. And so here is a specific example of a rule change that's currently under consideration, just to try and flesh this out a bit more fully. So what this rule change is doing is it would establish a 60-day transition period for a multi-state licensee who changes their primary state of residence. So let's say you move from one compact to another compact state. And what it's doing is giving you that deadline to apply for a multi-state license in their new party state. You can see in the rationale here that the goal is to add specificity and provide direction to nurses and other stakeholders regarding transition between these party states. So in a way to clarify this language. Next slide, please. So now I'd like to change gears a little bit here and talk about how the NLC impacts the processing of licensure applications. So there are three scenarios that I've listed below for you, and we're going to talk about how those work for states that are a member of the NLC. First, for nurses applying for licensure by examination, those who meet state licensure requirements and meet the NLC's 11 uniform licensure requirements are eligible for a multi-state license. You'll see here that I have elect/default for an MSL, a multi-state license. In some states, nurses who meet both sets of requirements, that is the state requirements and the uniform licensure requirements, receive a multi-state license by default. In other states, a nurse must specifically opt for this option, and that's up to each state to decide. Moving to licensure by endorsement. So there's a couple of options here. If you're moving from one compact state to another compact state, you need to apply for a multi-state license in your new primary state of residence. Now, let's say you're moving from a non-compact to a compact state. You're eligible in that case to apply for a multi-state license, and to receive that multi-state license, you would have to meet both the NLC's 11 uniform licensure requirements and the state licensure requirements. Lastly, and this is a bit different, if you're moving into a non-compact state, there's going to be no change in the licensure by endorsement process. If a state's not a part of the compact, they obviously can't issue multi-state licenses, and therefore the process is going to look exactly the same as it does today. The last case here is foreign nurses, and this process is going to mirror the license by examination process with a few small differences. Notably, the NLC's 11 uniform licensure requirements state that a foreign nurse must have graduated from an approved nursing education program. And what that means is that it was approved by the accrediting body in their home country, and that it's been verified by an independent credentials review agency. And what that review agency is going to say is this program comparable to a licensing board approved program? The last difference here is that for folks who are not native English speakers or whose programs were not taught in English, they must also pass an English proficiency examination. Next slide, please. So how does the NLC impact license processing time and workload? There are two key ways here in which the NLC reduces processing times and workload for licensing boards. First, the NLC eliminates the application processing time for licensure by endorsement for applicants who hold a multi-state license issued by any of the other 41 jurisdictions that participate in the NLC. That's because these nurses with their multi-state license have a privilege to practice in all 41 participating jurisdictions without additional applications or potential administrative delays. Second, the NLC eliminates the license renewal process for multi-state licensees who have a primary state of residence, the PSOR, that is not Hawaii. And this is because a multi-state licensee only needs to renew their license in one place, and that's their primary state of residence. Next slide, please. So lastly, I want to give you guys some data on temporary nursing permits and their relationship to the NLC. So from data that I've pulled from the 2022 NCSBN member board surveys, 38 jurisdictions reported offering temporary permits for RN licensure by endorsement, and 36 reported offering temporary permits for LPN licensure by endorsement. Critically, the NLC does not offer temporary multi-state permits. It only offers multi-state licenses to individuals who apply, meet home state licensure requirements, and meet the NLC's 11 uniform licensure requirements. I've given a few examples of the ULRs below. So those are things like, as has been mentioned, meeting home state licensure requirements, holding an active and unencumbered license, submitting to a criminal background check, and more. Next slide, please. And now we've got a break for open discussion. So I'd like to transition into open discussion and any questions that folks may have thus far.
If anybody has any specific questions, we wanted to put in place for you to do that. And I had a quick question in terms of the workload savings. Do you have the number, or maybe it's later in our agenda, do you have the number of nurses or that you think potentially would not end up being licensed in Hawaii because they would because they are an out-of-state resident, their PSOR is not in Hawaii, and they also have a Hawaii license? And do you also have those estimates of how many nurses in Hawaii may may hold a license in other states that are part of the compact, and so they may benefit from that? Like, what is the loss and what would be the opportunities for local nurses?
Yeah, definitely. So that information we will have in our fiscal impact section of the presentation. So you'll see those numbers, and then they'll also be contextualized in terms of things like license renewal fees, whatever, costs there may be. So that data will be in the next section of the presentation.
Does anybody have any questions so far?
It looks like Tom has a question. Yeah.
Oh, Tom.
Yeah, thank you, Laura. Aloha, everyone. Tom Heinrich on behalf of Representative Della Bellotti. She's on Big Island today doing site visits, so appreciate by sitting in. The question that I have basically is kind of anticipatory, and that is, with the work of the working group during this interim, et cetera, of course, I'm real sensitive to what our research attorneys may need to do in terms of other statements for either conformance or whatever else may come up by the working group. This is July. We got a fair amount of time, and a lot of work went in for the bill that was introduced this year. But just wish to encourage as we go along, if there are certain suggestions, Nicole, Robert, other folks that we have participating in the advice as we get towards our report, that some of those potential statutory elements that may be outside the Model Act are also highlighted in that report, so we can make sure that we have as clean a bill as possible in January to smooth this advance in 2024. Okay, so that's my comment for the moment. Thanks very much, Nicole and Robert.
And if there are no other questions, we can certainly move forward in the agenda.
Sure. All right. Let me share my screen again. All right. So hopefully we are back to the screen.
Nicole,
Oh, can you all still hear me?
we can hear you, but it's just says it's sharing your screen, but I think maybe your browser's not on that gross.
Got it. You know what? I'm getting a message. I'm on my phone with audio that Zoom quit unexpectedly. Let me open it back up.
Okay. Well, if anybody else has questions, we have a couple more minutes while Nicole is working out technical changes. Can I ask a question maybe for Tom and for our other and for our elected officials as it relates to Tom's questions? Do we need to bring in drafters or have a side conversation on how to address any recommendations or common instances that NCSBN identifies? Is there a best practice for us and how to integrate that into our report? If somebody is answering, I can't see if you're on mute. Okay, I'll follow up on that question offline. Back to you, Nicole. Oh, no, there she is. Never mind.
Oh, yeah. Can you all see my screen?
Yes, yes, now we see your screen.
Okay. Okay, perfect. Great. All right. So we'll move into talking about the fiscal impact. So Hawaii projections and examples from other NLC states. I think this is really important to understand. So we're going to be working off of a 2022 Hawaii fiscal impact report. And this is a projected fiscal impact to Hawaii. So first, let's talk about potential revenue losses. So first, why would a state be losing revenue by joining the NLC? So currently, Robert covered and explained sort of licensure by endorsement. Licensure by endorsement is when a nurse has a license in another state and they are looking to apply for an additional license in your state. So we'll use Hawaii as an example. So currently, if a nurse in Colorado wants to hold a license in Hawaii because they're practicing telehealth in Hawaii, they have some patients that are there, or many of their patients like to go vacation in Hawaii. They want to be able to reach their patients where they are and where they need their care. So they would like to get a license in Hawaii. Currently, they would apply for a licensure by endorsement and be granted a license if they met the requirements for such. So by joining the compact, and Colorado is a compact state, if Hawaii were a compact state as well, that nurse in Colorado would not need to apply for a license in Hawaii in order to practice there, so long as they were just practicing there and weren't changing their primary state of residence to Hawaii. So Hawaii would lose out on that licensure by endorsement fee that they would otherwise charge that Colorado licensee, because they're in the compact and you can practice in the compact with your one multi-state license, and you don't need to obtain and maintain additional licenses in other compact states. So in 2022, the projected revenue loss was around $1.2 million per biennium. This decrease was due to that endorsement renewal. So if you joined the compact, those nurses who hold licensure by endorsement licenses in Hawaii would likely stop renewing them because they don't need to if they have a multi-state license. And so that would be that loss in revenue. So the total here was calculated by multiplying the $176 renewal fee by the numbers there, 6,800 RNs, about 150 LPNs. So that's how that number was calculated. However, there is some potential revenue gain, so I'll walk through that as well. So for Hawaii residents with a Hawaii license and a license in one or more NLC state, and that number is right around 850, those nurses may decide that they want a multi-state license. So Hawaii is now a compact state, and they're currently maintaining 2 licenses, one in Hawaii and one in a state, one of the 41 jurisdictions that is part of the NLC. So many states, and we'll talk about this in the next slide as well, will charge an additional licensure fee for what's referred to as an upgrade to a multi-state license. So here we're assuming a $100 fee for these licensees who wish to upgrade their single state Hawaii license to a multi-state license, and that would give a revenue gain of about $85,000. Another group of licensees are Hawaii residents that do not hold a Hawaii nursing license. However, they do practice in one or more nurse licensure compact states. So right now, without Hawaii being in the compact, they have to obtain and maintain these other licenses in NLC states. Assuming that they would want to save money by not having multiple licenses across multiple NLC states, they may wish to instead apply for a Hawaii multi-state license, which would give them the privilege to practice in those other NLC states where they work. So even if they're not planning, if they're still continuing to not plan to work in Hawaii, it might be advantageous for them to get a Hawaii multi-state license. So you'll see the breakdown there, 211,000, 166,000 in potential gains from first endorsing those individuals and giving them a multi-state license. And then secondly, they're going to be renewing it upon Hawaii's renewal schedule. So that's additional renewal fees that are gained.
Hey, Nicole, this is Jennifer.
Yeah.
Deason. Can I ask a quick question on the first potential revenue loss?
Absolutely.
Is the number, the 6,817 RNs and the LPN number, is that the number who have in Hawaii already as their primary state of residence another state, or is that the total number?
So that number would represent those who do not have a primary state of residence in Hawaii, but hold a license in Hawaii currently.
So there's, I'm just trying to make sense of it. So based on this, there's almost 7,000 nurses in the state of Hawaii who don't consider Hawaii their home state?
Correct.
Okay.
And
how many nurses
Hawaii,
are registered
remember?
in the state of Hawaii in total?
I think the Board of Nursing's on the line. They might have that answer.
I'm gonna have to look that up.
Okay, it just seems like a really high number.
But just for clarification, though, I think you're talking about this 6,817 RNs. I'm sorry, this is Leanne, and the 158 LPNs who Hawaii is not their primary state of licensure. However, these are also people that hold a multi-state license in another state, right?
They may be, yes, yes.
I mean, that's how you're
Yes,
getting
they
those
do.
numbers based on our submission of our nurses data. You calculated that you matched some of these nurses who received a Hawaii license, single state license, that they already hold a multi-state license in another state. And that's why that's how you got those numbers. Is that correct?
So the number represents the nurses who hold a license to practice either as an LPN or RN in Hawaii, but do not have a primary state of residence as Hawaii, and they reside in a compact state. They don't have to hold multi-state licensure, but they reside in a compact state.
Okay, thank you.
Can I ask a question? This is
Yes.
Joan. How did you identify who these people were, who these nurses were that don't live in Hawaii but have a Hawaii license?
Yeah, sure. So through the nurses report, so nurses can pull data from states and look at where your primary state of residence is and where you hold licenses. So nurses is a licensure information system that all boards of nursing use.
Okay, so you guys pulled that for our state.
Yes.
Okay, and some of these people, these 6,000 and the LPN group as well, are they reflecting people who have like left within the licensure period? Got their license and then, you know, a year later moved to another state?
So I think that the data is pulled in, you know, in a moment in time. So I'm not sure whether or not they went through with renewal, for example, or if these RNs, you know, if all of these RNs are even actively practicing in Hawaii. So they may practice telehealth and, you know, have 1 or 2 patients in Hawaii a year or a month or, you know, et cetera. So it doesn't represent it doesn't give you a picture of active practice in the state, but it just tells you simply who holds a license in the state of Hawaii that does not have a primary state of residence in Hawaii, but rather lives in a compact state.
Okay.
So then under that logic, the 7,000 are renewing their licenses every year in Hawaii, even though they may not be living here, which is the rationale for the revenue loss?
And again, this was in 2022, so these were the numbers there. We don't know how many of them are continually renewing them each renewal cycle.
There's probably a mixture of people who left after they got their license and people who live permanently out of state and keep a license in Hawaii.
Yes, and I don't know this for a fact, but I would imagine that a decent number of the RNs and LPNs, or a big number, would represent military spouses or military families who may have a primary state of residence in another U.S. jurisdiction, and they are practicing in Hawaii as part of an assignment for their family in Hawaii. So that could capture some of these individuals as well, just as an example of the population.
And I see that Senator Sanjuana Ventura has her hand up as well.
Yeah, so yeah, you haven't answered my question. So it sounds like when you talk to Jen Diesman that the 7,000 people are paying the $176 renewal, but have claimed another state as their primary residence. So I guess my question is, why do we need, that's a more philosophical. If these people are able to practice, why do we need a compact then? I mean, I'm the one who introduced the compact bill, and I'm not sure whether or not we need it if these people are able to practice, especially if we're looking at a $1.2 million revenue loss.
Yeah, so I mean, that's a great question. There are a lot of benefits to joining the compact. I would say that these nurses are nurses that are holding multiple licenses across states, which is duplicative, which is expensive for nurses to do. And by joining the compact, they are, you know, alleviating a financial as well as an administrative burden. The same is true, you know, for boards of nursing. So for nursing boards that issue licenses, they are currently spending, you know, administrative time and resources to process licensure by endorsement applications for nurses who may be, you know, increasingly more mobile, increasingly practicing in the telehealth sphere, you know, looking for more flexibilities in licensure. And that is, you know, taking up time and resources as well at the administrative level in your state. So compacts allow for that flexibility for nurses to save money and administrative costs It allows for ease of recruitment, so individuals can be recruited and start working in a state without having to apply for, wait, and pay for a license, whether that's their first license or whether that's their 50th license. So the compact has a lot of advantages there. There is, of course, as you can see, potential revenue losses. There are also here some potential revenue gains. We have not, had a board of nursing that has enacted the NLC and has, subsequently withdrawn from the NLC due to any financial hardship. And, as more and more states are joining the NLC, this is becoming the reality for how boards of nursing are operating across the country, eliminating that need basically to do licensure by endorsement and streamlining a lot of their processes that way.
Thanks, Nicole. And this is Paige and Laura, hopefully I can just take a moment. I think, at our last meeting, we discussed a lot about the context around the compact. And I think it's important to look at the projected fiscal impact. But I think, one of the things that we did at our last meeting was we talked a lot about sort of why there's an interest, and I can speak for our members, right, who are employers, and I think we represent, one sort of a position on the compact, is that this is really a tool for us to be able to bring nurses in potentially during times of great need, such as during the pandemic. I want to actually sort of remind the group that we're actually still currently under an emergency rule at the DCCA. The DCCA and PBL and the Board of Nursing have done an incredible job with a lot of resources that were provided by the legislature, right, by Senator Sanborn and you and your colleagues, to get temporary staff to help with the backlog, because I think one of the reasons that we started having this conversation in earnest is it was taking up to 6 months in some cases for RNs to receive a license in the state. The pandemic contributed a lot to that. I think that there were some unavoidable issues that came up with the backlog, with the need for surge staffing. But I think what we recognized during the pandemic was having some flexibility to bring in staff when it was needed, whether it was because of a need for surge, a need to fill in some critical roles. I think as we're looking towards more of a new normal, what we hear sometimes from our employers is that sometimes they just, last minute have to fill in a role. They can't wait, right, even a month or so to be able to bring in folks. So I think from the employer perspective, it's not just looking at it in the context and this vacuum of what the losses and gains look like. It's about having a very flexible, a very responsive system that we're able to use, and that we believe could provide some benefit and some, I think some nurses here would look at this as a potential benefit and would want to be able to have a multi-state license. So I think, Senator, that's partly what we're looking at is the workforce. It's a piece of the workforce puzzle. I really like what Laura said, that it's a puzzle. It's a piece of it. I don't know whether it's on the edge or in the middle, but I think it's much more than just the license. I think it's about the flexibility, it's about the standards, and it's about being part of a system that I think could work really well for nurses here, but could also work for the healthcare organizations that bring in the nurses.
Hi, this is Eric Abe from the Hawaii Primary Care Association. I'd like to reiterate what Paige had said. From our organization standpoint, we look at this legislation as dealing more with health and safety, and that ultimately employers need to have the flexibility to bring in healthcare professionals when the needs demand it. And ultimately, it's because of the need to bring in healthcare professionals that the HPCA has been in strong support of this legislation. And so while there may be some potential revenue losses, I think ultimately we need to look at whether or not the state has a deficit in the number of healthcare professionals throughout the state, and whether or not there are adequate means to bring in healthcare professionals into areas that need them. Thank you.
Are there any
If-
additional
if I could-
questions?
Yeah, if I could just add, Nicole, I think the other thing too is, we have a lot to learn from other states, and Hawaii is implementing a compact, right? So I appreciate what Eric is saying too, is that, I think part of it is we're trying to look at it holistically. We're looking at physicians, so it's not just nurses, right? We also are looking at mental health professionals. We're looking at how to beef up the entire healthcare workforce, and I think potentially looking at what's happening with the physician side too, I think could be helpful, because that is a choice that the legislature made, was to pass a compact for physicians. So I think these are really important questions. I want to emphasize that. I think it's really important, and we have recognized the importance of making sure that DCCA and PDL are adequately funded, I think, through the pandemic, and we've tried to work with them really closely on how we can be supportive, and then of course HSCN too, just incredible work there. But I think that we want to kind of look at it in that more holistic framework, and then also, if it's something that we think is potentially good for physicians, right? Where else can we look in our workforce that it could be helpful?
Laura, sorry, this is Laura. We do have time on the agenda in future meetings to have conversations with DCCA and divisions within DCCA to ensure that we have those conversations, and as well as others. So there will definitely be a full opportunity to discuss that specifically with our local colleagues at the Department of Commerce and Consumer Affairs.
Laura, this is Linda Beechnor. Could I make a comment, please?
Yes.
Thank you. This is Linda Beechnor from Hawaii American Nurses Association, and we speak for the nurses of Hawaii, and we're working very hard on identifying and working towards ameliorating the actual issues for retention and recruitment of nurses in Hawaii. From our perspective, the NLC is a Band-Aid approach, and that could be remedied easily by the temporary license bill that was introduced in the legislature last session, which would have allowed DCCA, the Board of Nursing, to issue temporary licenses, which they have done for decades, within a couple of days for nurses who live in other states. And that bill was passed over, but it would directly address the issue of it taking so long to get people licensed in this state. So we're really concerned about the lack of attention to the actual causes of the critical nursing shortage in Hawaii. And we really feel like this is a distraction. Thank you.
Thank you, Linda.
So this is Nicole. If I can just, because I think it's a really important point to make distinctions between temporary licensure or even other reciprocity or licensure waiver processes. I think we need to remember that the NLC, the Nurse Licensure Compact, is a two-way street. And so in addition to allowing some of the flexibilities that we heard just now from Paige and others about, facilities being able to recruit and make sure that we have enough providers in order to care for the patients, to meet the patient needs. This could be during acute times, such as when there's an RSV outbreak, or it could just be, on the day-to-day, if you lose a specialty nurse in your pediatric unit, to be able to recruit from a broader group in order to fill that need quickly. However, when we think of temporary licensure, remember that it just works one way. That's with individuals coming to Hawaii. So that doesn't provide benefit to Hawaii nurses who may practice across state lines. It doesn't apply for Hawaii nursing students who want to go into the telehealth field, and they know that by staying in a non-compact state, that will be astronomically more expensive to be able to hold, obtain, and maintain multiple licenses. So just thinking about, and of course, the military spouse population, who are huge supporters of the NLC, we think about when they're relocated to Hawaii, yes, temporary licensure could get them licensed faster and get to work faster. But when they leave Hawaii and maybe going to one of the 41 jurisdictions who are in the NLC, they are going to meet hardship there because they won't be able to begin practicing immediately upon relocating to those states. So I just want to, stress that when we think about the NLC, it's not only about getting nurses to practice, to come to Hawaii, but either physically, it's also about telehealth, treating patients and being able to reach patients in Hawaii from elsewhere, but also for Hawaii nurses to have a benefit to practice in the growing telehealth arena and remain competitive. As Paige said, there are so many licensure compacts now for healthcare professionals. And so, this flexible license allows nurses to remain competitive in today's market as well.
Can I ask a question? This is Joan, Hawaii Nurses Association.
Yeah.
Let's say I live in a non-compact state, can I get a compact license in a compact state?
No, so the way the compact works is similar to a driver's license. You obtain your license in your primary state of residence. Once you obtain so if your primary state of residence is a compact state, you apply for the multi-state license. If you meet the qualifications, you are issued a multi-state license, and then you only have the privilege to practice in other compact states. So it's based on your primary state of residence. If you move and you change your primary state of residence, then you would need to, and it's a compact state, you would need to reapply for a compact license in that state. And then if you meet the qualifications of that state, as well as the compact, then you're issued a multi-state license there. So it is entirely based on your primary state of residence. And that, of course, is the same definition used for tax law, used for your driver's license, getting a new ID, et cetera. So it's based on your primary state of residence.
Okay. And when we're on the financial part of it, what is the cost what would be the cost for a nurse in Hawaii for the compact, to be licensed under the compact?
So let me jump into the next slide because I think we're heading in that direction. So let me talk about the fiscal impact to the NLC states. So first of all, and Robert covered this earlier, what's the cost of the NLC? So each party state to the compact pays a $6,000 annual membership fee. Again, that comes from the state to the NLC. So that is the membership fee. How is the NLC being financed in states that have enacted it? So that fee structure is entirely decided by a party state. And that's why I didn't want to answer the question, because it's going to depend on how Hawaii chooses to proceed. So I'm giving a couple different structures here as examples and a couple different states that are using those structures. So in Florida, for example, what Florida does is charge a one-time fee for a multi-state license. So for those nurses living in Florida who may have been practicing there 20 years before the compact was enacted, and they say, hey, I actually want to explore this, or I already practice in a couple compact states, so I think a multi-state license will be beneficial for me. They would apply to the Board of Nursing for a multi-state license and be charged a one-time fee. So that fee would be, considered like an upgrade fee from a single state license to a multi-state. So that could be range in anywhere, whatever the Board of Nursing sets the fee at. Other states actually give you an option. So when you're applying for a license, you have the option of obtaining a single state license, that would be an SSL here, or a multi-state license, an MSL. So Oklahoma has taken that route. So upon applying for licensure in Oklahoma, you elect whether you are getting a single state license or a multi-state license. If you get a multi-state license, there's a higher fee that you can charge. Again, that's how you can recoup some of this loss. This is entirely up to the state, has nothing to do with the compact. It does not govern fees. So the state, it has the choice to charge a higher fee for a multi-state license. And then that higher fee could translate over into renewal as well. So there might be a different renewal fee for renewing your multi-state license. So that is a way that not too many, but a decent amount of the 41 jurisdictions have chosen to either charge a one-time upgrade fee from your single state license to a multi-state license, or have a different fee structure entirely for multi-state licensees versus single state licensees. There is also a cost associated with other compacts. So all compacts, are a little bit different. Many of them operate in a similar way, where you hold one license with the privilege to practice. But when it comes to how they structure their fees, the NLC is different. So the IMLC, which is relevant since Hawaii passed it this session, charges each applicant has to pay $700 to the commission, to the governing body, plus state licensure fees in each state that they intend to practice. So this is per licensee. So again, with the NLC, there's a $6,000 annual membership per state to the NLC commission. That is a one-time per annual fee that you pay. It's not per licensee. For the psychology compact, there is initial fees and renewal fees paid to the commission per licensee. So that's a cost on the licensee to provide to be provided to the commission or the compact. So you can see that there are a lot of different structures. The NLC has the structure where it receives no licensure fees. It simply receives a $6,000 annual membership fee, which Robert mentioned helps with their operations, with their meeting costs, etc. So I'll pause there if anyone has any questions as to any of this.
This
Who
is
is the, sorry.
sorry, this is Laura Reichart. Is it common that the single state license fees ever change, or is it typical that states maintain that same rate for the single state license fees, or is that something you don't monitor?
So, and let me see if that question is the first one on this slide. So are you asking of what nurses opt for a multi-state license over a single state license?
No, so for
Oh,
states,
sorry.
for nurses who do not opt for the multi-state license, is there any change to their licensure?
Oh, no, there is no change. So the compact can only govern multi-state licensure. So the single state licensure remains exactly the same. Whatever fees the Board of Nursing sets, or however fees are set in your state, will remain that way. And importantly, just as a reminder, again, the compact does not dictate fees for licensees. So it could never say that each compact state needs to charge $200 for a multi-state license. It's simply not within the powers of the compact, and that is all left up to the states, and the licensure fees go to the states. The only fee to the commission is $6,000 a year.
How does, this is Joan. How can this, the NLC survive and have anything on $6,000 from, 50 states or 36 states or whatever the number is right now? How do they make their money? Like, how do they pay their salaries? Because that's not very much money. It seems like a lot for nothing.
Sure. So yeah, I can help answer that. And I think Robert covered it in sort of the expenses for operating the NLC. So in addition to the $6,000 per year paid by members, the NLC, the quasi-governmental agency commission, does have a memorandum of understanding with NCSBN to help cover staff costs, as well as some meeting costs as well. So the NLC only has 2 employees. That is the executive director and an associate that helps with the operations of the commission and help with implementation of the state. So there are only 2 employees that are actually, salaried under the NLC, and the party states, commissioners certainly do not make any money in their role as commissioner.
The whole program that's being offered only costs $6,000. I mean, I don't know the backside of the program. This is just some of the other parts of it.
So, and I don't, yeah. So that is the only fee.
Okay, I don't understand.
So
I guess I
Nicole,
need
it sounds like the reason that NLC, it sounds like the nurse licensure compact has 2 employees. And the purpose of those 2 employees is to essentially sort of work on the administration of the NLC, but that a lot of support comes from the NCSBN. So that's kind of a lot of the way it's designed, is that NCSBN is supportive of the work of the NLC. And that they're kind of 2 separate things, but there's a lot of support from one to the other. Did I understand that correctly?
Yes, that is correct. And not to say that the commission's work isn't important, but it is important to remember that the states are the ones who continue to license individuals, who enforce their State Practice Act, who discipline and investigate any instances or take complaints. So the work of regulation remains with each individual member state. So it's not like they're suddenly the commission isn't a licensure agency. It's not enforcing a Universal Practice Act. It is simply governing the operations of the compact.
So if I can, Nicole, so just to help me understand a little bit too. So NCSBN, right? So that's all of the boards of nursing, right, in the country. And they've sort of said, okay, as an organization coming together, right, we're supporting the structure of this compact. But I think what I'm also hearing you say, and this may come up a little later, I'm guessing there are discipline sides. I think what you're saying is part of the way that it's structured is that states still have a lot of autonomy, right? And it's designed that way because each state and each board of nursing wants to make sure that they have the ability to investigate or take action against a license, right? So it's designed to be state-based, is kind of what I'm hearing you say, to allow autonomy for the states to continue.
That's exactly correct. Yes,
Okay.
The entire purpose of the NLC is to facilitate multi-state practice while maintaining the regulatory structure of state-based licensure, state-based regulation, state-based discipline. So regulation remains with the state, and the compact is simply, again, the commission is facilitating the operations of the compact. So any matters that come before it, whether it be, like Robert was talking about, some of those rulemaking changes that they might need to consider in light of questions that might come to them, provide clarifying statements, but they are not issuing licenses, regulating licensees. All of that remains at the State Board of Nursing level.
Okay, so if I may, I think because I want to make sure I understand it, in some ways, and it's clearly not apples to apples, but it's sort of like how Medicare, right, for our hospitals, right, they set out all of these requirements, but ultimately, right, it's like we have to meet the requirements of the state, right? Well, I guess for hospitals, it's different commission, but so for nursing homes, right, it's like at the end of the day, we have to meet all of these kind of requirements as laid out in federal law or regulation. Not that this is federal law or regulation, but at the end of the day, there's a lot of state autonomy and we have to respond to OCA, right? And so there's still a lot of that focus at the state level. This might not have been a good, I'll think about it if there's a better way to sort of, but I see what you're saying. So it's really, it's an administrative function.
If I may,
Absolutely, and only has governing authority over the multi-state license.
I think another way to think about it is that it's sounding like the nurse license compact is the conduit to make the existing structures collaborate or correspond. And so there are, and there's not just state, and I know that I asked Nicole and Robert to talk a little bit about this in the disciplinary actions section, but there are a number of requirements that, and Robert talked a little bit about them, the 11 uniform license requirements, but all of those structures have to be in place, are in the state, but some of those are other programs of NCSBN like nurses. So there are other programs existing, so it's not like, I think that it's building up existing resources that make it solvent or stable, or maybe solvent and stable, and instead of being really disenfranchised, it's not only the state implementation, but it's also bolstering up these other resources that NCSBN as an organization has stood up. So there, I think that there are many pieces, and there's probably a lot of analogies that we could move through, but also for sake of time, if we can let Nicole go a little bit further and help us consolidate, because she may be able to answer some of our questions.
Great, thank you so much. Yeah, so on this slide, talking, again about fees or about, obtaining a multi-state license. So what is the average percent of nurses who opt for a multi-state license versus a single state license? So they say, I want a multi-state license, I want to be able to practice across state lines, or I might want to in the future, and I think that I'll get the license now. Well, as we mentioned, there are states that operate and you get to choose how you are going to operate as an NLC state. Will you default to the multi-state license, meaning if I'm a new grad and I apply for licensure in Hawaii, and Hawaii is a compact state, will they screen me for the 11 uniform licensure requirements under the nurse licensure compact? And if I meet them, will they just give me a multi-state license? Or do I have to opt for it? So it's hard to determine what the percentage is of nurses who opt for it, because there are states that do use the default method. However, what we can share, or not share, but what we do know is that there's around 2.2 million RNs and LPNs who currently hold a multi-state license. And that's across about 38 jurisdictions, because not all have implemented and started issuing licenses yet. So what's the average fee increase for a multi-state license? Again, this is going to totally depend on the state, whether or not they charge a surcharge for a multi-state license or that one-time upgrade fee, like states like Hawaii follow. Another question that came up was, where do multi-state licensee holders report earnings? So if they live in Hawaii and they are practicing in multiple states, let's say they practice in a telehealth company that practices in Arizona and Colorado, they would need to report income tax as appropriate per state and federal tax law. So the NLC does not speak to a nurse's earnings or where they need to file taxes. They would need to comply with state income tax reporting laws in the states where they're working, as well as federal law. So this was our time set aside for open discussion. I think we obviously were taking questions as we went along, but are there any additional questions on what we discussed? If not, I'll just turn it over to Robert. All right, shall we just continue then, Laura?
Please do.
Okay, thank you. Robert, take it away.
Alrighty, so I know we've kind of started to broach this topic, but we're now going to game out and talk a bit more specifically about how discipline works under the NLC. So this is going to cover things like e-notify for institutions, information sharing, and also investigations. Next slide, please. So the first thing I really want to do here is lay the groundwork. What is e-notify? And these questions will all kind of build on each other. And ultimately at the end, Nicole will kind of game out how this works with more specificity. So if you don't understand something quite right now, hopefully these pieces do come together. So e-notify has two different sides to it. One is e-notify for institutions, and the other one is e-notify for nurses. For nurses, it's very simple. E-notify allows them to keep up to date with their licenses. So this is something like renewal deadlines, the status of their various licenses, and things of that nature. For e-notify for institutions, an institution may enroll nurses that they employ, and this allows them to receive automated license and discipline notifications. So let's say in the event a nurse is disciplined, what this means is that the institution that participates in e-notify would receive an alert that an adverse action has been taken against a licensee they employ. So this is something that they'd get instantly once discipline occurs, and all boards of nursing participate in e-notify for both RNs and LPNs, which means, there are no information gaps here. It's not like information isn't being fed in from, say, Missouri or Texas, or, pick another state as an example. In terms of cost, e-notify is free for both nurses and employers, and there are no supplemental or add-on fees. Currently, this is something that 11 employers in Hawaii use, including the Veterans Health Administration. As we'll discuss later on during the workforce part of the presentation, participating in e-notify for institutions is one way that employers can comply with specific reporting requirements that a state may choose to adopt when enacting the NLC. Next slide, please. So now I'd like to turn to the process of discipline. And there are a few key questions here to address. The first one is, how is a nurse reported for investigation? And how a nurse is reported for investigation under the NLC does not change. The status quo continues to hold. So in cases of suspected misconduct, a nurse may be reported for investigation to the board or other appropriate agency by their employer, by another nurse, a member of the public, or anyone else who's eligible to report that nurse for suspected misconduct. Second, and I think this is critical here, since we've already started some of this discussion, the NLC does not subsume state agencies. Rather, what it does is empower state agencies to take action against multi-state licensees privileged to practice. So you can see here in the Model Act, Article 3, Section D, that all party states are authorized to take adverse action against a multi-state licensee's privilege to practice. So what this means is that if Hawaii were to enact the NLC, RICO would retain its authority to investigate nurses licensed by Hawaii. So that's both licensees that are single state licensees and multi-state licensees. And it would be authorized to investigate and take action against nurses practicing in Hawaii under a multi-state privilege to practice. So critically, under the NLC, discipline investigation happens where conduct occurs. So you're bound by the state practice laws at the moment and location that care is delivered to the patient. And this means that, the appropriate disciplinary body retains their authority to investigate and discipline nurses as appropriate. And another question we see here is, well, will this create additional workload for RICO or for any other investigatory body? And the workload difference here is negligible. To date, no jurisdiction that's enacted the NLC has hired additional investigatory or legal staff as a result of joining. The caseload difference is in effect a wash. Next slide, please. Now, the last thing I'd like to talk about here is the coordinated licensure information system that's required under the NLC. And what this does is help coordinate nurse licensure and enforcement efforts. You can find this all in Article 6 of the NLC Model Act. So sharing information between party states is aimed at improving efficiency while furthering a party state's responsibility to protect public health and safety. That tool that is used is nurses, and that's what the compact uses to share information. Every jurisdiction in the United States participates in nurses, even those that do not participate in the compact. And it enables information to be shared across jurisdictions as well as to the public in certain circumstances. So under the terms of the NLC, party states are subject to a reporting mandate, and that requires them to share any adverse action as well as any current significant investigatory information with each other. That can be something that may pose a threat to patient harm or to public safety and public protection, as well as things that rise above the level of, incidental misconduct. Now, the compact mandates that party states report this adverse action taken against a multi-state licensee. So that's either against their license itself or the privilege to practice. And this allows other boards to see action that's been taken against multi-state licensees. Additionally, even prior to any adverse action being taken, party states are required to alert each other about that current significant investigatory information. This is a flag, essentially, that boards can raise, allowing other boards to contact them for additional information. And now I'm going to let Nicole really speak to this in greater detail and game out some of the situations, which should hopefully clarify some of the above.
Thank you so much, Robert. So we'll turn to discipline, and we'll talk about discipline in your primary state of residence versus discipline in a party state to the compact and what that looks like. So just as a baseline, let's remember that under the compact, you only hold one license. So if your primary state of residence is Hawaii, that is where you would obtain a multi-state license. What you have in every other jurisdiction then to practice in the other party states is what's called a privilege to practice. So you have one license, and in the other party states to the compact, you have what's called a privilege to practice. So if we look at what discipline in your primary state of residence looks like, your primary state of residence is the only authority that has disciplinary authority over your license. So if your primary state of residence takes disciplinary action against you, your license would be considered encumbered, which is a disqualification for holding a multi-state license. So essentially what happens here is if a Hawaii nurse is with a primary state of residence in Hawaii, has a multi-state license, and they're disciplined, something occurs, the conduct occurs in Hawaii, and Hawaii goes through their disciplinary process, and they choose to revoke the individual's license, that is going to automatically disqualify them for their multi-state license and therefore shut off the privilege to practice across all the party states. So by taking action against the license, which only the home state can do, the primary state of residence, you are effectively turning off the privilege to practice in all of the additional party states. So what this means for a nurse is that they would no longer be able to practice in other compact states unless they went and applied for single state licensure and qualified to get a licensure by endorsement in other states. Discipline in a party state looks similar but different. So if a Hawaii licensee is practicing in Colorado, for example, and let's say there is a complaint that they have diverted drugs, the Colorado Board of Nursing investigates, just as Robert said, your investigative body continues to do the important work that they do, whether you have a license or a privilege, and they investigate the issue and they take action against your privilege to practice. What that does is effectively, if you can picture a map, it turns off Colorado. So Colorado is no longer a state that you're authorized to work in. They have taken action against your privilege to practice and revoked it. So you can still practice in your home state of Hawaii or any other party state to the compact, so long as those states do not take reciprocal action. If your home state takes reciprocal action, we're now in category 1 on this slide, where that would mean your license is encumbered and therefore you're disqualified from holding a multi-state license altogether. But each state, just like today, just like the status quo, each state has the ability to take action against your license if there is action taken in a state. So it maintains the authority for your state to protect the public, which was paramount to why the compact operates in this way and allows boards of nursing to continue doing the important work, or investigatory bodies like RICO as well. So I want to pause here and just ask if anybody has any questions about this process.
I do.
Yes.
This is Joan. So in this sense, if someone's disciplined or have action taken against their privilege or license in another, they're a Hawaii nurse licensed in Hawaii, practicing in Colorado, and Colorado takes action and against their privilege to work there, and then Hawaii can choose whether or not they want to follow the decision made by Colorado. What happens with appeals and like this, is Hawaii obligated to actually do a separate investigation, or they just take the investigation and decision made by another state? How does that work?
Yeah, so that's a great question. So the complaint and the investigatory process, and again, this works just as it would today in a non-compact situation. Because the conduct occurred, let's say in Colorado, Colorado has an interest in, of course, investigating what happened. They also have the proximity to, the employers and subpoenaing and doing their investigative work. They would be most natural to conduct and complete the investigation there. Then Hawaii, just like boards do today, when you might hold a separate license in Hawaii, they can take a look at that action and they can determine whether or not they want to take action against the individual's privilege or licensure in their own state. So that's similar to how reciprocal action would take place today. It doesn't require a separate investigation. Certainly it's up to a state if they choose to, that they want to know a little bit more before they take action and go through that process, but there is no requirement that multiple investigations are done. I think that, boards of nursing, all committed to protecting the public, are, working to do thorough investigations to make sure that they've got it right and issue appropriate discipline. And so that will continue under the compact as well.
Hey, this is Jennifer. Can I ask another question? So earlier in the slide where we had the conversation about the revenue loss and the PSOR, does that mean that in this circumstance, there are those 7,000 nurses in Hawaii who haven't declared their PSOR as Hawaii go through this disciplinary process?
So the disciplinary process, so it doesn't change whether your primary state of residence is Hawaii or whether it's Colorado. The disciplinary process doesn't change. The only thing that is impacted is that if Hawaii is your primary state of residence, they can take action against your license, which would impact your participation in the compact, versus if you're in a state where it's a party state to the compact, it's not your primary state of residence, they can only, the highest action they can take is revoking your privilege to practice, but that doesn't impact your license or your ability or privilege in other states.
And can I ask Nicole, this is Paige, and maybe this is actually a question for the Board of Nursing. I mean, that sounds pretty similar to what would be done for a temporary license, right? Because I would assume that right now Board of Nursing couldn't take action against someone's license, right, in another state if they're working in Hawaii temporarily. I guess that's kind of, maybe that's a Leanne Board of Nursing question is how is that different than with the temporary? Or I don't know if Nicole, you have any insights from
Okay,
the national.
so this is Leanne. Right now, so under the governor's emergency proclamations that allowed an out-of-state nurse to come in and practice, obviously we didn't issue a license, right? So when that person came in, if they did anything, diverted drugs or whatever they did, and then just moved back to the mainland or wherever they came from, that would be up to the facility to report that to the appropriate authorities. They don't hold a license with us. Technically, we couldn't do anything because basically the license requirements were waived. Under the current emergency rules, it's the same thing. It is up to the quote healthcare entities at this point. If they determine that the person, neglected a patient, diverted drugs or whatever it is, they would have to report it to the appropriate authorities. Unfortunately, again, the emergency rules pretty much only provides them the authority to practice under these certain conditions with a healthcare entity. There's no license or disciplinary action that we would take because we didn't issue anything to them. They have temporary authority to work. So it is a little different. In this case, it sounds like they have some kind of property interest should Hawaii join the compact and we start issuing multi-state licenses. That person now has the privilege to work in another state. That state can take action against that quote privilege. We can also take action against that quote license if there's a violation. Does that make sense? I don't know, Paige. I don't know if I answered your question.
Yeah, no, it does make sense. And I guess then also my question was previously, right, when we did have temporary licenses. I mean, I assume it's somewhat. Yeah,
right.
It's about the same system.
Yeah, so that one we actually issued like a number and the authority to work. So yeah, it's a little different. Sorry.
Can I follow up with that?
Yeah, go ahead.
Hi,
Sorry.
this is Sorry, this is Esther Brown from RICO. I just wanted to follow up on what Leanne was sort of talking about, which is the PTP, the privilege to practice. So I certainly understand, if a home state takes disciplinary action against the license that they issued, then if it's a multi-state, then the PTP and the other jurisdictions sort of fall to the wayside or go to sleep. So my question is, what does that look like? What exactly is that? Would that be considered a revocation in the other jurisdiction? Is that considered a forfeiture? What is that exactly, practically speaking?
Yeah, so let me see if I can answer, if I got your question right. So what we're talking about is a primary state of residence taking action and encumbering the license.
Yes.
So, okay, so Hawaii takes action against a PSOR, a primary state of residence licensee in the state of Hawaii, and they decide to, let's say, suspend the license for a year. What happens is that they no longer, one of the requirements of the compact is that you maintain eligibility for a multi-state license. So because an encumbrance, you have to have an unencumbered license to have a multi-state license. Because the license is encumbered now, you no longer are eligible for a multi-state license. So that same suspension of a year is placed on the multi-state license, which effectively turns off the multi-state privilege in all of the other states party to the compact. So those states are taking no action. That is an action of the home state that only they can do because you hold a license in their state.
Okay, I'm still trying to figure it out practically.
Yeah, and
that-
I'd be happy to also, follow up if you have other questions, certainly, and to anyone, if there's more detailed questions that you'd like answered, we're certainly, available for you to send them our way. We can provide them in writing if it's easier to understand that way as well. I know that this can get sticky, so I want to make sure that we're providing the best information in the best format.
I do have another question, Nicole. What does the PTP look like? Leanne was saying there's no document, no number. So say, for example, there is a nurse here in Hawaii who we entered the compact. They have a multi-state in their home jurisdiction, let's say California, well, not California, Washington. And they come over here on a PTP to practice, and we got wind of some sort of allegation of misconduct, and we want to start investigating it. What do we put down? Right now, when that happens, we put down the Hawaii license number to start our investigation. What would we put down for somebody who's here on a PTP when we begin our investigation?
Sure. So within the nurses system, there are going to be PTP action codes. So similar to how you would take an action against a licensee, you'll be taking an action against their PTP. So the license number, and I can get you that information as to what the exact number would be. It may be the MSL number, the multi-state license number, and then you're taking an action against their privilege, because again, you would only be able to take action against their license if you were the PSOR.
Okay, thank you.
Yeah. So I want to cover just real quick this last discipline slide. So discipline under the NLC, and I think this is, Laura had included references to this in the agenda to both of these articles, but I think they're important to highlight. The first one being, paramount, is that a 2022 study found that there's virtually no difference in multi-state licensure and single-state licensure disciplinary rates. Why this is so important is, first of all, the compact was created only if it can be safe, right? Only if it can protect the public, because that's the mandate of the boards of nursing. So that was, key to our members when drafting the compact and putting it together. So thrilled to see that multi-state licensure and single-state licensure disciplinary rates there's virtually no difference between them. Importantly, too, is that discipline rates among nurses is low, which is great and speaks to the value of the profession and, and the work that all nurses do. So the study found that multi-state licensure rates are 0.23% disciplinary rates, and for single state rates are 0.24%. To the extent that there is any difference, once that data is broken down by the state or, other measure, to the extent that there may be a difference, the article does point to the fact that in order to qualify for a multi-state licensee, you have to meet additional requirements. So these additional requirements may in fact account for the difference in disciplinary rates. Again, to the extent that there are differences, it's very, very small. So I definitely wanted to highlight that study, but also I think Leanne just brought up, in Paige's question, brought up this idea of, what happens, how are nurses held accountable, and how is the public kept safe when states are issuing temporary orders, executive orders, licensure waivers, et cetera. And there's a really great reference to an article, a case study in the Journal of Nursing Regulation in 2022 that highlighted, during COVID, the threat to public safety by some of these executive orders that simply waived licensure requirements. In a lot of cases, never issued a temporary license, never even required registration, but simply waived licensure altogether. This article importantly highlights why a permanent solution like the NLC provides for that patient safety element and process that, I think our colleagues from RICO were just talking about is so important. How does this get done? Under the NLC, it's clear that you can take any disciplinary action that you otherwise would for a licensee in the state in order to protect the public. However, if we take an example like what happened in New York, where licensure was waived completely, no temporary licensure system was stood up. Simply, if you had a license anywhere, you could practice in New York as a nurse. So what happened was a Missouri nurse in this case study went to New York to practice under that emergency order, and while in New York, diverted controlled substances. New York was alerted, New York's Board of Nursing was alerted to this by the employer reporting it. However, they determined that they had no jurisdiction to take action against the nurse because they were there simply under the executive order waiving their requirement to hold licensure in the state. So they could not find that they had jurisdiction to take action and protect New York's public against this nurse. So that raised a serious concern, not only among the Missouri Board of Nursing, who of course was, the nurse held a license in Missouri. That was the authority by which they were able to go to New York and practice under the waiver. And it really demonstrated and highlighted the fact that no matter an emergency, when it's absolutely necessary to help as many people as possible quickly, and these provisions had very good intentions as to why they were put in place, it highlights that having a permanent solution in place for times of emergency, crisis, disaster is so important, and the NLC allows for maintaining public safety while also addressing the needs of the disaster or emergency. So definitely recommend that as a read. Did someone have a question? Okay. All right, so yeah, I guess I'll pause here for a second. Oh, Rena?
Yes, hello, good morning. Arena Chung from RICO. Could I go back to the earlier discussion on additions to model language?
Yes.
I understand that Washington State, in enacting the enabling legislation this year, they added on a requirement particular to their state that mandates that hospitals that employ multi-state licensed nurses must report the fact of that nurse's employment to their state board of nursing within 30 days of hire. Am I correct in understanding that this requirement does not substantively change the compact addition, the compact provisions, and is therefore a permissible state-specific addition of language to their enabling legislation?
You are absolutely correct. And Robert is actually going to highlight that exact provision in Washington statute in a moment. But yes, that provision is allowable under the compact. The reason being, and what's key about why having the legal review of the legislation is so important, that the way that Washington crafted the language, and we work with them to craft that, is that it is a requirement of employment. So employment by that Washington employer, that they report to the Board of Nursing that they have hired a multi-state licensee, and that is a requirement that the employer must fulfill, not the multi-state licensee themselves. So yes, that is correct, and we'll look at that language in a moment.
I see. Thank you very much, Nicole.
Yeah. All right, so I'm going to turn it over to Robert. Oh no, Robert, this is still mine. Apologies. All right, we'll move into workforce, and then Robert will finish up. So looking at the NLC and workforce planning. So a question on the agenda is, what plans does NCSBN have to investigate the NLC's impact on the nursing workforce planning? So importantly, I want to talk about the National Nursing Workforce Survey. So the 2022 survey that was just completed and the results were released, I believe, in April, does have questions pertaining to the NLC and multi-state licensees and how nurses use their multi-state licensee. So here's an example of that, asking them about participation in care delivery via telehealth, distance education, disaster support, or other. And so we're gathering data through the National Nursing Workforce Survey, which helps to, of course, paint a picture of how the NLC is used, how many nurses are using it, how many nurses are holding multi-state licensees, et cetera. The Nurse Licensure Compact, the Nurse Licensure Compact Commission, so the governing body, does have several committees that it has created to explore different things. So for example, a marketing committee, a rules committee. So these are charges that are given to them by the commission to look into areas of interest to the commission. One of those committees is the NLC Research Committee, and they have a research agenda with several research ideas and are looking, currently at receiving some grants in order to conduct some of the research to look at how the NLC is utilized across the country. So these are just, two examples of ways that, at least on the national level, the NLC is being studied. I think what we just talked about with some of that additional language that is being added into bills that helps states build a better picture of how the multi-state licensees in their state may be acting, and maybe where they're working and what type of work they're engaging in while in your state. So now I will turn it over to Robert.
Thanks, Nicole. And yeah, Rena, this is exactly where you were going with your question about Washington. So some states have included, as part of their legislation enacting the NLC, requirements that seek to gather valuable nursing workforce data or ensure that nurses have specific competencies. As Nicole alluded to up top, because of the contractual nature of a compact, you can't unilaterally condition a nurse's multi-state privilege to practice. However, these can be made a condition of a nurse's employment. So for example, and there are two listed here, a state may place a requirement on employers that they report nurses with multi-state licenses issued by other states that they hire. Another example would be that the board can make it voluntary for multi-state licensees with PSORs outside of that state to report when they're working in the state. And there are a few states that have gone this route: Washington, Rhode Island, Louisiana, and Kansas. They've all adopted language targeting workforce data collection and specific. And now I'd like to specifically highlight Louisiana for a moment. Their enacting the NLC directed the Board of Nursing, as well as the State Board of Practical Nurse Examiners, with developing a reporting system aimed at collecting aggregate data from employers on the number of and geographic representation of RNs and LPNs employed in Louisiana who are practicing on a multi-state license, and this data needed to be submitted prior to an RN or LPN providing care. So one way that they actually implemented and complied with this reporting requirement was through the use of e-Notify for institutions. So e-Notify is kind of one tool in the toolbox that can be used to comply with any of these reporting requirements that may be spelled out. And now, Nicole, if you'll go to the next slide. we can take a look specifically at what was included in Washington earlier this year. And just to kind of highlight the specific areas that are most relevant, those are bolded and underlined. So in item 1, you can see that any individual employed by a hospital who holds a multi-state license issued by a state other than Washington has to complete any required demographic data surveys. And again, this is made a condition of employment. It's also worth noting here that this language did not apply just to hospitals, but was extended to apply to other types of healthcare facilities. In item number 2, you can see something targeting a specific training. So this was requiring multi-state licensees with multi-state licenses issued by other states to complete a suicide assessment, training, and management module that was required by law as a condition of their employment. And then the last item, item 3, sets out a timeline in which hospitals are required to report the multi-state licensees that they've hired and attest that they've completed the required training and surveys as a condition of their employment. What all this demonstrates is that there is flexibility in the enacting statute to create reporting requirements that solve the need for accurate and timely workforce data, as well as any desire to make sure that nurses practicing in the state meet certain thresholds and have specific competencies. So that is one example. And with that, I believe we're at the end of our substantive slides. So again, we can open the floor for any discussions or questions on the workforce.
Aloha, Robert. This is Esther from RICO. Thank you for showing the examples of what Washington is doing. Who is the hammer for employers and hospitals that may not meet that requirement of either having the nurses fill out the demographic survey or getting the information to the boards of nursing? Because right now we are the hammer. They report it to our board of nursing and we have the information. So do you have any idea, like for example, in Washington, what sort of enforcement mechanism they're thinking of in the event there is non-compliance with those reporting?
Yeah, I'm actually going to kick that one to Nicole. She was a bit more closely involved with the crafting of that language. So I think she may have a better idea of, how that came to be and what they're thinking in that regard.
Great, thank you.
Yeah, thank you, Esther. So the way that these provisions in Washington's law, and like Robert mentioned, it's not just for hospitals, it's for nursing homes, for other nursing pools, many different employers. Those are all under their employer regulations or statutes. So that would be up to the department that regulates employers to ensure compliance with those provisions. Any other questions?
Sorry, it's Leanne. Can I just chime into Esther and Nicole's response? Nicole's response to Esther. Currently, under the emergency rules, nurses are authorized to work under a healthcare entity licensed by the Department of Health, right? So if any kind of language to require these quote healthcare entities who hire multi-state nurses or whatever, we would probably adopt that kind of language. Would have to get Department of Health's permission to include it under their license requirements for those healthcare entities. Does that make sense? Sorry. I know what I'm trying to say. I don't know if it just came out that way, but yeah. But I think that's how we would look at it. I know what your question is. I had the same question and yeah, we would have to ask Department of Health for their permission to amend their laws or rules to require healthcare entities provide that information or complete the survey. Because we wouldn't have jurisdiction over them. Yeah. Sorry, go ahead.
And certainly, oh no, thank you, Leanne. And certainly we have examples, like Robert mentioned, many states have put into place different provisions than just Washington. Rhode Island actually specifically looked at Washington's language and carved out a piece of it that it wanted to put in its NLC legislation that was enacted. So there are many different ways to do this and many examples that we can send. Again, I don't know the legislative drafters when working with them to look at how it might best fit into Hawaii statute.
I have a
And-
question.
Sorry, if I can just Nicole, I'll just follow up that this is something
Go ahead.
also Esther and Leanne and Nicole, we can bring back to our members, which are, the hospitals and nursing homes. And we can look at what happened in Washington and Rhode Island too. We've got great relationships also with DOH, right, with our folks on that side. So we can also help with that conversation. So we'll bring that back as an action item for us to check out.
And-
what the input is.
And we can ask them to come to a future meeting to have that discussion in this open forum as well.
I can I just ask a question? So so besides the flexibility of working in different states, because you have a license that can go across state lines. What else does the nurse compact, like, is there anything else that's going on here besides just that? Because we obviously have to discuss how would people be disciplined, because to me, there's like this whole big thing, like what else? Because for $6,000, to me, it's not believable that that's like that free, like there's got to be something else that's different. And my concern is, and on some level, is that the organization is not a government agency. It's a private company, right? A private nonprofit, I'm assuming. And the governance of that falls to who?
So
Because it's your
the
license,
commission
right? Yeah, go ahead.
So yeah, thank you for that question, Joan. The commission itself is a quasi-governmental agency. Similar to how Hawaii just passed the IMLC, it creates a commission. That's how compacts are governed. So the commission structure is not unique to the NLC, certainly not unique to healthcare compacts. Hawaii is actually a member of 20 plus compacts. The commission governs the operations of the compact. So again, it's not doing any of the licensure functions, disciplinary functions, etc. It is simply governing the coordination between all of the states in allowing for this licensure mobility to take place. As to your question about sort of what else and who else is this benefiting, we find that nursing educators are very supportive of the NLC because it allows for institutions to do more distance education, to reach students where they are, to have students that might be located in a rural area still participate in a nursing program and have access to nursing education from where they are. Again, military spouses, we know the benefits there. I do also want to say that as we are getting to a point where currently we have 41 jurisdictions in the NLC, if a nurse is going to move to Hawaii, because who doesn't want to move to Hawaii from our perspective sitting here in Illinois, if they want to move to Hawaii, a nurse is currently making a decision from a compact state. Do I want to move to Hawaii, which would make my primary state of residence Hawaii, and give up on this privilege, on this benefit to my license to participate in maybe telehealth, maybe travel nursing, whatever type of nursing that you want to practice? If it needs multi-state flexibility, by moving to Hawaii, I am giving up my ability to have that license. So we do need to think about, compacts as they're getting more popular and more states are joining on. There is a real loss to a nurse, and that means a deterrent to recruiting nurses into the state if they know that if they're moving to Hawaii, they're no longer going to have that flexible license that they might need for their job or they might want for their future.
Okay, so that's good. So what else does so the compact is the compact, but the compact is getting us into what? Besides the licensure part, is there anything else? Is it going to be like our new like Nurse Practice Act? I mean, how does it, there's nothing else, so the only document that we have to worry about is the actual license, the compact document, which is like a 15-page, 30-page document, and there's nothing else besides it that we are beholden to?
Joan, you're the first person who's acted like the compact's a small bill. I like that. It is a large bill. It's about 30 pages. And again, it just details the contractual elements. There are rules, right? The commission has rulemaking authority, but what they can govern is operations of the compact only. Scope of practice never can be touched by the compact. How you issue a license, requirements for licensure never can be touched by the compact. Disciplinary actions, never. This is simply facilitating something that your state of Hawaii has chosen to enter into. So they just purely have an operational and governance function. It is not another entity. It is not another board. There is no staff. There's no attorneys. There's no investigative staff. It is simply just operational.
So can I ask Nicole, because I think I'm trying to, when we first talked about this, right, we had reached out when I think the compact really came up last session, and I wanted to understand it. And I think, if I may, and I really appreciate that Joan's kind of trying to get to the core of it. But this is my understanding, right, is that essentially every state has a board of nursing, right? And the board of nursing is tasked with the safety, right, of every patient in the state based on, being able to regulate and follow up, right, with various types of licensed individuals, including nurses, right? So we have this board of nursing, right, for nurses. And really what the compact is it's a state saying we elect into an agreement, right? We are trying to elect into an agreement that is binding a lot of different states to be able to essentially provide this benefit for nurses in multiple states. But that really it's agreeing to go into this kind of pool and this agreement, but it's not saying, okay, everything has got to get thrown out, right? We want you to sort of listen to what we're saying. There's not going to be any collaboration, right? It's not that. It's essentially paying into this agreement or being able to kind of function sort of in this larger pool. I don't think I'm explaining it as well as you did, but I think that's the core of it, right? We're not trying to throw everything out. I think the idea is that we're kind of like with a lot of other types of clinicians saying, I think we can all agree on this base, and we're coming together to work together in a cooperative way to benefit people in Hawaii as much as possible and benefit people in other states. That's the choice.
Hey, Nicole, this is
Michael.
Mike Robinson with Hawaii Pacific Health. I had a question, going back to the Washington example. I just wanted to confirm that was an accommodation to accommodate pre-existing statute that existed before the compact model language came to the legislature, or was that done at the same time? In terms of
that was done in the same bill. It was done in the same bill.
Okay. No, I guess my question is that the modification to the model language, was that done because there was a pre-existing state requirement for employer reporting, or was that done at the same time as the model language was being done?
I see what your question is. Thank you for that. Yeah, so in Washington, first of all, they've been looking towards advancing the NLC for many years. And as part of those discussions, some of the concerns raised were, number one, how am I going to know that a multi-state licensee is working in my state? Number two, we have continuing education requirements around suicide prevention. How are we going to ensure that these multi-state licensees have completed that? Number three, workforce data. We want to know those, not only that those individuals are there, but we want to know about their demographics so that we have accurate workforce data and better workforce data to work with. And so those issues, those were not requirements of the employers in the state of Washington, but by enacting the NLC and adding these provisions, it removed a lot of the concerns of some lawmakers, of some stakeholder groups, and the employers agreed to, implement these provisions and create a reporting requirement with an attestation that the other two were completed. So the demographic survey data, that's completed by the nurse. The suicide prevention training, that's completed by the nurse. But within 30 days of employment, and again, the 30-day number, it just, that's what Washington chose. I think in Rhode Island, you were providing information, reporting multi-state licensees, Robert, correct me if I'm wrong, I think 6 months or annually. So it was a much longer period than just 30 days. So it's not a magic number, that's not model language. That is for Hawaii to craft for Hawaii's needs, if that's the path that you choose.
Okay, and then just as a follow-up to that, and you mentioned it was tied to employment. So do you recall what State Department in Washington State was responsible for the oversight of compliance to that requirement? Was it their Department of Health or was it another?
I can get that information for you. I know in Louisiana, it was the Department of Health. I do specifically remember that. And they coordinated that the institutions in their state use e-notify for institutions. Again, it's free. And that was the mechanism that they chose to report that they had hired multi-state licensees to the Board of Nursing, which was the statutory requirement. But I can look it up in Washington. And they're in the implementation process, I should say. And so they're currently figuring out how exactly they're going to go about this, how they're going to enforce it, et cetera. So that's an ongoing process that Washington's going through right now.
Thanks.
Well, we are post time, so thank you very much, Nicole and Robert, for sticking with us and answering all the questions as they came at you, as well as presenting to us quite a bit of information. I think it'll take many of us a couple days or even weeks to digest all the information we provided. So as I mentioned at the top of our meeting, I do hope that we can invite you back and continue this conversation. It's particularly as we continue to explore factors within our state, I think we'll just keep on adding layers of knowledge, and also probably have a long list of questions that the more you know, the more you know you don't know. So we are in this period of inquiry, and we appreciate your participation. With that, it is 12:10, and so I want to release everyone from this meeting. Thank you so much. We will meet again in 2 weeks' time. We're working on putting that agenda together. And then for any of the follow-up information, Nicole and Robert, if you are interested in making any connections to follow up individually, you can either go through me and I can forward that information on, or I should say me and Amy Ono, or I'm happy to make those connections so you can engage in further correspondence on a one-on-one basis.
Perfect. I'm also just putting my email address in the chat so people have access to it should you need. Feel free to reach out to myself or Robert as well, and we can make sure to answer your questions. And then if they're helpful to the group, we're happy to share that information as well.
Thank you very much. And we will be sure to send your emails out to our working group members.
And I'll provide a copy of the PowerPoint, Laura. I'll send that your way.
Thank you very much.
Great, thank you.
All right, aloha and have a good rest of your day.
Thank you. Bye, everybody. Thank you.